I want to say thank you to all of the kids that came up and read the amendments and all the participants in the essay contest. It's a huge part of what we do, and we're so happy that you took time out to participate. It is my honor and privilege to introduce our guest speaker. And if you watch TV about politics in the area, you're probably familiar with one of his shows. I love to watch it because he always put candidates and elected officials in the hot seat. But our guest speaker is the Honorable Judge Shively.
Well, I can't put them in the hot seat anymore because I need them. I need the county commissioners, I need the county council for money to operate the court, so I have to sort of slow down a little bit. I'm so honored to be here today. When Jill asked me to do this several months ago, I didn't know quite what to expect and didn't know much about the organization and about this event, but as I kept asking folks, I learned a lot, and I think this is a wonderful, wonderful program. And they asked me to be here today to talk about the Bill of Rights. But you can't start a discussion of the Bill of Rights without talking about what was going on in this country shortly after we won our independence. We formed this form of government called the Articles of Confederation. That was an absolute mess. Envision, if you will, all 13 states were autonomous. They all printed currency. They all had their own tax programs. They taxed residents of other states. And that these federal governments, the central government, had no ability to raise money or provide for a common defense at a time when this new country was so vulnerable. We didn't make the folks in Europe very happy when we created the United States. So we quickly found out that articles were not going to work. So our forefathers got to work on the Constitution. That's not something they did overnight, as you well know. Much debate. The Federalists, the pro-strong central government, the anti-Federalists. How are you going to bridge the gap, get these people together, to put together a better form of government, better blueprint, if you will? Well, after much fighting, exchange of correspondence, Federalist letters being exchanged in public, we did come to the point. Let me hold it?
Yeah, if you don't mind, it's hard to hear you.
Okay, well, can you hear me better now? All right. So our forefathers got together and began the process of developing and ultimately ratifying the Constitution, which is a marvelous document created by geniuses, if you think about it. They were able to do several things. First of all, they created three branches, separate, co-equal branches of government: the judiciary, the legislative, and the executive. Also, they were able to balance the rights of the states and yet create a strong central government by putting in this Constitution enumerated powers that the central government had, leaving everything else to the states. And one of the powers the strong central government was given was the power to raise revenue and to provide for a common defense. Tremendous document. Had everything you need to outline and blueprint the structure of government. One thing was missing. One big thing was missing. How does this new government relate to the people? And it was just a year or so following the ratification of the Constitution, we began work on what is now called the Bill of Rights. And that's what we're here to celebrate today. Before we get into the Bill of Rights and its ramifications then and now, I thought it was really impressive, the students that read each of the amendments. It didn't take very long, did it? I'm impressed by the brevity of those amendments, but yet the power in the words. Our forefathers meant those rights to endure forever. Now, the first 150 years from the adoption of the Bill of Rights, there wasn't much court action. The Supreme Court didn't really get involved in interpretation of the amendments. But the one thing they did recognize, that these amendments at that time only apply to the relationship between the federal government and the people. After the Civil War, the 14th Amendment was adopted. And within that is when we start segueing into how these Bill of Rights apply to the states. And in the 14th Amendment, it said that no state shall deprive any person of life, liberty, property without due process of law. Now, you would think that that would start the ball rolling, extending the Bill of Rights to state situations as well. It wasn't until the 1960s that that began to happen. So I want to begin a review of our Bill of Rights, not in the order that we are presented today, not in numerical order, but in terms of how these rights affect our daily lives. The 3rd, 7th, and 9th, and 10th Amendments are somewhat more esoteric and really we don't deal with them in our daily lives like the others, which I'll get to in a moment. The 3rd Amendment, I might add, which states that no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner be prescribed by law, I would submit to you is the most successful amendment adopted. Because I've yet to have the Indiana National Guard knock on my door and wanting to stay in my basement. The 7th Amendment was basically a codification in some respects of existing common law, allowing litigants in civil cases to have the right to trial by jury if the amount in controversy was above a certain amount. The 9th Amendment, a one-liner. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The 9th Amendment was the cornerstone of this right of privacy that underscored Roe v. Wade decision back in 1973. Most recently, in the Dow decision, that was reversed, and the constitutional right to abortion was abolished. It's going to be very interesting to see how the power in this amendment in the future, but that was the underpinnings for the Roe v. Wade decision. And finally, the 10th Amendment states, again, a simple one-liner. The powers not delegated to the states by the Constitution nor prohibited to it by the states are reserved to the states, respectively, to the people. And the reason I think this was put on at the end, it was a reaffirmation of the goal of the Constitution to balance the rights of the federal government with the states' rights. All right, let's talk about those amendments, those Bill of Rights that have most effect on our daily lives. The First Amendment, freedom of speech and freedom of religion. That's not just by accident that became the First Amendment. Keep in mind, this country was founded on the basis of the suppression of freedom of religion by the king, as well as the inability to redress grievances with the king. So our forefathers believed for this country to survive, we need to protect those rights at the forefront. The freedom of religion contains two aspects. Number one, free exercise. And we still today, we're expanding and litigating what that means. But essentially, the Supreme Court has held that one has the free exercise of the right to express their religion in employment settings and otherwise, so long as it does not have a substantial detrimental impact to other functions. The Establishment Clause. Again, one of the things our forefathers were trying to avoid was what they had in England. The King of England was the head of the church. If you wanted to worship in any way, you had to do it through the King's church. And they wanted to make sure that government was out of the business of establishing religion. Now, the interpretation of this Establishment Clause has extended over to such things as the validity and constitutionality of school prayer. However, most recently, the High Court found that a prayer conducted by a football coach at the end of the game in the end zone did not infringe upon the Establishment Clause. So I would say to you, the First Amendment on freedom of religion is always in a state of flux. As far as freedom of speech is concerned, political speech is given by the court the highest scrutiny and the most protection of any speech. And one thing to keep in mind, not all speech is protected. Libel, slander, as Justice Holmes once said, yelling fire in a crowded theater, those aren't protected speech. A little footnote here. In the news lately, all about Twitter and social media, and some of our not so well educated politicians start talking about the First Amendment. The social media problems are created by private entities. The First Amendment only applies to government. So if we're going to deal with social media, we got to find another way to do that. All right, the Second Amendment. This is the one that amazes me. Again, a one-liner. A well-regulated militia be necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. It took until 2008 when the court held for the first time that the Second Amendment is not connected with a well-regulated militia. It's an individual right. And then shortly thereafter, the High Court, I guess putting more power in that decision, stated that this interpretation also applies to the powers of local and state governments. All right. The next 4 amendments basically involve the rights of criminal defendants in this country. The 4th, 5th, 6th, and 8th Amendment. The 4th Amendment, which basically prohibits citizens being subject to unreasonable search and seizures, requires that no one's person or dwelling or business or what have you can be subject to search by government except upon the presentment of an affidavit under oath by proper authorities establishing probable cause and the need for that search that is signed off by a judge, and basically any evidence obtained otherwise is illegal and unconstitutional. Well, that right until 1963 only applied to federal matters. It was the Warren Court, Chief Justice Earl Warren, that expanded this right into state criminal court proceedings. And not only did the Warren Court do that, they established this thing called the exclusionary rule, or sometimes referred to as the fruit of the poisonous tree, which meant if the law enforcement people bust into your home and find contraband and want to introduce it as evidence in your trial, it will be excluded because they did not properly obtain it as required under the 4th Amendment. That's a big right, and the exclusionary rule over the years has kept law enforcement honest. To show you how the 4th Amendment has been interpreted by the court to meet modern situations. If a defendant is arrested and they have a cell phone on them, the police can't just take that cell phone and start cranking through that to find out what emails and text messages there are. The High Court recognized, just like your home, your person, your cell phone is not just a communication device. Your whole life is on there. Your medical records, your social security number, a myriad of items are on. It is your life, okay? And the only way that the law enforcement, even though they made a lawful arrest, can get into that cell phone, they have to go do a separate search warrant to a judge established by probable cause that within that phone there is information, credible information regarding the instrumentalities of a crime. Okay, the 5th Amendment. Again, this was loaded with rights to the people, especially in the context of criminal proceedings. Number 1, requiring a grand jury before one can be charged. By the way, the grand jury requirement still applies to federal charges, not necessarily state. The states, for the most part, have moved away from grand juries. The 5th Amendment also created double jeopardy protection. If the prosecution tries somebody today and they're acquitted, and 2 days later the prosecution gets new evidence, they can't retry that person. What a great protection. The 5th Amendment also provides that any deprivation of one's life, liberty, has to be done by due process of law. The Sixth Amendment. This is chock full of rights. Guarantees a criminal defendant the right to a speedy and public trial. A trial by an impartial jury when one's liberty is at stake. To be informed formally of charges before one is put through the trial process. The right to confront witnesses called by the state. The right to ask the court to compel witnesses to testify in the defendant's behalf. And here's the most important part of the Sixth Amendment. The assistance of counsel. And if you can't afford an attorney, the state appoints one for you and pays that attorney. Again, the Warren Court extended those rights to state criminal court proceedings in the case of Gideon versus Wainwright. Finally, the Eighth Amendment. And this was kind of a sleepy amendment for a while until we started having these cases brought by the ACL, for example, dealing with jail overcrowding, prison overcrowding. And the theory behind those claims, which were successful, I might add, was the fact just because someone's been found guilty of a crime and sentenced to so many years in a penal institution doesn't mean they have to live in dangerous and hazardous conditions. Moreover, the Eighth Amendment also been applying to forfeiture proceedings where, for example, a person is convicted of drug charges and the government confiscates their vehicle. That's considered a penalty, and those, whether that's appropriate or not, is also weighed under the Eighth Amendment. Now that we have completed our review of the Bill of Rights, some closing observations. First of all, the impact of the Warren Court on the Constitution is, to me, the most impressive, especially when you think about Earl Warren's background. He was the governor of the state of California. He was a former prosecutor. His father was a police officer killed in the line of duty. And Dwight David Eisenhower, the president who appointed him, probably thought his guy was going to be a good law and order, conservative person to place on the court. But another aspect of Earl Warren, he was a strong intellectual, and he had undying fidelity to the rule of law. And we find in all the actions in the early 60s, the expansion of the Fourth, Fifth, and Sixth Amendment are due to his commitment to the rule of law that will be with us forever. He wasn't looking at any political ideology. He was focused on the rule of law. These fundamental rights we are celebrating here today will endure so long as presidents appoint nominees with intelligence and a fidelity to the rule of law, and not to a particular political persuasion. And those senators that sit in judgment to confirm these nominees must also evaluate accordingly. In closing, the power, therefore, to protect these rights is ultimately in the hands of the electorate. Thank you, folks. Appreciate it.